I'm sure.
What did you make of the state's argument that this doesn't affect people's legal status at all?
The state is attempting to rewrite the law the legislature passed in an effort to save it. That's what they're trying to do here. They're faced with a plainly preempted law, and they're trying to fix it now, and they just can't do that.
Can you explain the state obviously was saying that their clients, Doe and Roe, would not be affected, but can you explain the aspect with the Violence Against Women Act and the people who potentially under federal law would be protected, but under Senate File 2340 would not be protected?
Sure. So the statute prohibits stopping proceedings while people pursue federal immigration benefits, right? It explicitly says that people with pending applications with the federal government, even those people can be prosecuted under this law. The legislature considered an amendment that would have required that they stop prosecuting people who are applying for immigration benefits under the Violence Against Women Act, so victims of domestic violence, and the legislature rejected that amendment, making it very clear that this law is intended to target people who would otherwise be eligible for federal immigration benefits.
What did you make of the judge had questions, and forgive me, I can't remember if he was referring to a former case or current statute that seemed to include states' abilities to enforce the immigration laws. What did you make of that?
Sure. So there's a Supreme Court decision. It's called Arizona because Arizona was the state that tried to do this, though to a lesser degree actually. They weren't quite as ballsy as Iowa has been. And that Supreme Court decision absolutely controls the issues in this case. In that case, the Supreme Court said that the federal government regulates the field of immigration, and when they do that, you can't pass laws, even if you're trying to help the federal government, because the whole space is occupied by the federal government. And the federal government rejected the idea that Iowa's putting forward here, that just because they're trying to enforce federal immigration law, and they have the same goals as the federal government, they can do it. And the Supreme Court said no. When it's an immigration space, only the federal government gets to control that. And there are good reasons for it, including, as the Department of Justice argued today, foreign policy concerns, right? How we treat non-citizens in this country has huge foreign policy implications. And if the states get to do it, then they risk interfering with these international affairs, with our diplomatic relations, in a way that really hurts the United States as a whole.
This was mentioned a bit toward the Texas law. How would what's going on in that case right now potentially affect this, and at what point could that happen?
Sure. So a district court in Texas and then the Court of Appeals have both held that the Texas law, which is very similar to this law, is likely illegal. And those decisions, they're not binding on this court. They don't have to follow them, but they're certainly very persuasive, right? When a federal Court of Appeals does its own analysis and says this is unconstitutional, this judge is obviously very concerned about that and will take their reasons very seriously. So it's likely to influence the judge's decision in this case.
The judge seemed interested in this issue raised by an amicus party that U.S. Statute 1326B, apparently their argument is that it shows Congress intended to give state courts some role in removal proceedings, if I understood that correctly. Can you address that?
Sure. So there's a sentence in the federal legal reentry statute that talks about people can stipulate to removal, meaning basically like a plea agreement, right? You're not going to fight removal, and that even those stipulated removals, when they happen when someone's in state criminal proceedings, can have effect. But the statute does not give the state authority to enter removal orders or to enforce them. And as the Department of Justice argued at the end, right, it's to the opposite actually. The immigration statute specifically says that removal decisions can only be done by the federal government through the particular laws that Congress has set up.
I guess just kind of general housekeeping for folks that weren't able to be in there. Kind of, what is your legal argument of why you don't want this to take? Who wants this to go on?
What's the legal claim here?
Yeah.
Sure. So the supremacy clause of the Constitution says that federal law, that states have to follow federal law. And when there's a word called preemption, you've probably heard that thrown around, right? And that's basically, that comes up when federal law makes it impossible for the state, or says you can't have a particular state law. And we have two arguments here. One kind of preemption is when the federal government has such a dominant interest in a space, has put so many rules and so many statutes that there's just no room at all for the state to legislate. Even if the state is trying to help the feds, there's no space for them. And we say that's true here. And then the other kind of preemption is when there's a conflict. So when a state law, like for example, the federal government says you have to file your taxes on April 15th. If Iowa says you have to file them on April 20th, you can't do both, right? That's called conflict preemption. And we argue that that applies here also, that there are all these ways in which the state law makes it impossible for the federal law to be complied with, including, for example, that the state law doesn't include an exception for people who re-entered lawfully, whereas the federal law does. And that's a clear conflict. The two don't work together, and so the state law has to get the boot. Questions? Okay.
All right, Veronica asked me to